Yes, Mr. Ramlogan.
My Lord, I believe when we took the break, we were on the affidavit of Larry Williams, and I was going to take you to paragraph 12.
That's in the supplementary bundle.
Yes, the supplementary bundle from yesterday.
Page 86, I think.
Yes, and I'm on paragraph 12.
Yes. Thank you.
I'm obliged, my Lord. And paragraph 12, this is what Mr. Williams said. He said the rate of conviction by the state in murder cases in this jurisdiction is extremely low. I have not seen any official statistics from the appellant on this issue. However, the last known study was commissioned by the University of the West Indies and the Center for Criminology at the University of Oxford, entitled An Arbitrary Fate Conviction for Murder and the Mandatory Death Penalty. He quotes from it, and at the bottom of the page, the statistics which were given, it says in paragraph 46, how successful were these prosecutions? As table 11 reveals, of the 279 indicted for murder, where proceedings had been completed, only 58, that is to say 20.8% or 1 in 5, had been convicted of murder. My Lord, that report was exhibited to his affidavit in the application for the stay. My Lord, when we took the break, we were on the separation of powers point, and of course, I don't intend to traverse that ground in light of that. What I do wish to say, my Lord, is this: there may be appropriate cases, and I'm not saying this is one of them, because this can be decided on breach of sections 4 and 5. But there may be appropriate cases where section 4 and 5 might not necessarily be breached, and resort to that additional principle, the wider principle of a breach of sections 1 and 2, based on the rule of law and separation of powers argument, would be relevant. And I do not wish for the door to be shut on it, as it were. And I say that, my Lord, only because in the judgment I've put in this bundle, at page 2, at page 92, Stone Street Capital Limited. This is the bundle from this morning now, sorry, beg your pardon. Just by, that's at page 92. That is a case recently decided in Trinidad and Tobago, where the court found neither that there was no breach of a fundamental right, but the case was decided on separation of powers and breach of the rule of law. I'm not going to take you to it, but I just wanted to let you know why I came back to it, because I do not want for us to close the door on any future case that can appropriately raise it. Now, my Lord, on the question of assistance to the board, if we can keep that bundle, on the question of assistance to the board, on the Section 13 test, I'd mentioned before that the Belmarsh case, and I understand, I wanted to bring to your attention what was said in that judgment. And I readily appreciate what my Lord Hodges said about the fact that there's no equivalent of Section 13. But to the extent that the judicial deference to the executive policy arises, you couldn't ask for a better case by way of illustration, because, I mean, it dealt with, anti-terrorism and so on. And at page 28 of this bundle, if I take you to, before I go to page 20, page 26, sorry. So page 26, paragraph 39, this is what the court said. While any decision made by a representative democratic body must of course command respect, the degree of respect will be conditioned by the nature of the decision. As the European Court observed in Fretti versus France, the contracting states enjoy a margin of appreciation in assessing whether and to what extent differences in otherwise similar situations justify a different treatment in law. The scope of the margin of appreciation will vary according to the circumstances, the subject matter, and its background. In this respect, one of the relevant factors may be the existence or non-existence of common ground between the contracting parties. A similar approach was taken in R versus DPB. Lord Hope said, it would be easier for such a discretionary area of judgment to be recognized where the convention itself requires a balance to be struck. And I say section 13, by analogy, requires a balance to be struck and invites the judiciary as the final arbiter and decision maker of where that balance lies. It will be easier for it to be recognized where the issues involve questions of social or economic policy, much less so where the rights are of high constitutional importance or are of a kind where the courts are especially well placed to assess the need for protection. Another area in which the court was held to be qualified to make its own judgment, for example, is the requirement of fair trial. Quoting LaForest J., courts are specialists in the protection of liberty and the interpretation of legislation, and are accordingly well placed to subject criminal justice legislation to careful scrutiny. However, the courts are not specialists in the realm of policymaking, nor should they be. And quoting Justice McLaughlin below, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. We cannot, because of modest estimates of our competence in such specialties as public education, withhold judgment that history authenticates as the function of this court when liberty is infringed.
Well, I don't wish to stop you citing this, but all these dicta are made in the light of very different constitutions. I mean, what we have here is a constitution which empowers the legislature by supermajority to depart from certain fundamental rights, but gives the court as final arbiter the right to nevertheless hold that legislation is invalid if it doesn't come within the proviso.
Indeed, but my lord, if you minus section 13, or even if you have it, isn't the result the same really in actual reality? Because here, for example, the courts are clearly empowered to be the final arbiter of whether or not where the balance should be struck, and whether it was reasonably justifiable or under the umbrella of proportionality. Whatever the test you use, the role and function of the court.
Again, I don't think anyone is disputing that for a second.
Yes.
The court is the final arbiter of the interpretation of the Constitution and its application to the facts of the case. I don't think that's in dispute for a second. But at the end of the day, in striking a balance, we have to take as our starting point that the Constitution has allowed the democratic legislature by supermajority to depart from the fundamental rights. And we then have to, so that when we're applying a de freitas or banc melat approach, we have to give weight in each of the four stages, give weight to the fact that the legislature has exercised this power.
But I just wonder, my lord, I mean, is it not the case that in the English legal system here, one can argue by way of analogy that the Parliament also has the right to pass a law that interferes with fundamental rights, and the judiciary is the final arbiter. If it's a proportionate and justified interference, then the interference would be justified and constitutionally compliant. And held to be constitutional. And if that be the case, by way of analogy, are we really that miles apart between Section 13 and that function and the principles that, that should be applied?
Well, I think we are a long way apart for the simple reason that wearing a hat as a member of the UK Supreme Court, I and my colleagues would have no power to say an act of Parliament was unlawful under the human rights legislation.
Yes, well, my lord,
So the Constitutional Court imposing limitations on a democratic legislature is conferred with more power than exists under the domestic constitution of the United Kingdom.
Fair enough, my lord. My lord, all I can say is, my lord, to the extent that there may be, it may be analogous, the board may wish to consider whether some of the principles and jurisprudence that might that provide some guidance and some handrails in cases like this can be extrapolated into our context. I take it no further than that because I appreciate what my lord has said. If I take you next to page 147.
In the same volume?
In the same volume. And this is the letter that we had written, which was exhibited to the affidavit of the respondent. You will see at the bottom, we asked for number 2 at page 147. At the bottom, we asked for the rate of, this is a letter to the appellant. We asked for the rate of conviction for murder in Trinidad and Tobago for the past 5 years to be provided. We asked for, number 3, on the next page, the number of persons who have been executed. We know the answer is 1999. 4, the number of persons who were charged for murder that have been granted bail since the application for a stay was refused. 5, the average length of time it takes from the date of charge to the date of trial for murder, which would be then the pre-trial detention period. And then we said the reports that had been commissioned by the state into the subhuman and terrible conditions on remand. And we then list a long list of reports that have been commissioned, or some of them are parliamentary subcommittees, etc., Inter-American Court of Human Rights. And we ask that those matters be brought to the attention of the board. Unfortunately, that disclosure has not taken place, but we say that it would have been relevant, of obvious relevance and assistance to the board. And it is not something that the respondent could have assisted you with.
Well, again, this is a request being made for evidence after the case is coming before the board on appeal. It's not normal to be evidence gathering at the stage of court of final appeal, is it?
It's not, my lord. But my lord, I'll put it this way: if evidence that can be of assistance and relevance to the court in determining issues before it can reside within the bosom of the state, and there is a duty to make, a continuing duty to make full and frank disclosure on the state, it should have been disclosed even at the high court stage. But the short point I'm making is, if they have the relevant information and they don't produce it, there's only so much that the respondent can do, and the failure to produce it is a matter, you know.
Was this requested at high court stage?
My lord,
because that's when you should be gathering evidence to advance these matters.
But my lord, no, I can't say that there was a request for it at the high court stage. But my lord, the duty to provide assistance to the court is not dependent upon the applicant making that request. It's an independent duty to make full and frank disclosure, yes, on the state, and that's what I'll say to that. My lord, the next point I want to make is, my lord, it is a matter of some consternation. This is a case of immense and fundamental public importance to the Republic of Trinidad and Tobago. And when I started off yesterday, it has caused great consternation that a submission from the state that the justification for Section 5 is that the Parliament did not trust the court. and reference was made to the Hansard. And it would be, if someone were to say that the British Parliament doesn't trust Her Majesty's courts to administer the laws that it is enacting, it would be a very serious matter. It goes to the concept of a sovereign democratic state and the separation of powers. So what we've done in the small time given to us, because remember we received that Hansard yesterday from the appellant.
It's referred to in our case. So it was all referred to in our case. It just happened not to get into the electronic bundle. There was one to get in there by error.
Yes. In any event, to bring matters to a head, what is it you're wanting us to take from the Hansard?
Yeah, my lord, what we've done is we have provided my little friends with the Hansard, but I didn't want to burden you on too much paper. But what we've done is to extract from the Hansard some of the quotes from the debate to show you that, contrary to what we think the impression was given yesterday, there was robust, vibrant exchange, and some of the very points that have been made here were in fact being made. And can I take you at the end of page 152, if you turn to the page after that,
yes,
you will see, these pages are not numbered, but you'll see at the top, we've come to the conclusion that the government cannot put a blanket measure in place to put into the hands of the police authority the power to deny bail merely by laying charges or additional charges. This is, in fact, what you are doing. That right must be subject to judicial review by judicial officers. Why are we skeptical about putting more and more power in the hands of the executive of this country or in the hands of the police that are part of the executive? I will tell you why. We have very strong reasons, and a reason is cited which had to do with the execution of a prisoner. If I take you to the page overleaf, Mr. Sahid Hussain, who was the Member of Parliament for Siparia.
I don't quite understand where this is going, because Mr. Knox reposes great confidence in the judiciary not granting bail in murder cases. That's the whole basis of his argument. And so as far as this case is concerned, he's not, as I understand it, making any suggestion that the judges cannot be trusted, because he says there is a rule in effect, in practice, that bail isn't granted, despite the residual discretion.
Yeah.
So he cannot, on the one hand, say, I trust the judiciary in relation to bail, in murder cases, and the other hand saying, I don't.
I'm deeply obliged, because the submission was, the rather bold submission was made that the justification for the socio-political justification for the legislation was that the Parliament did not trust the courts. But
I didn't take Mr. Knox's submission to be to that effect. I think it was somewhat of a throwaway line, if I may say so, that it might be that some parliamentarians were less trustful of the court, but that wasn't his justification of the legislation.
That's not my recollection. I thought it was squarely put as a submission that part of the policy was that the legislature did not trust the judiciary. That was firmly stated yesterday. And if it's now being said, well, there's an internal contradiction in what Mr. Knox says, so be it. But that was my understanding as you are submitting.
I'm deeply obliged, Shimla, because that was my understanding as well.
I think I did say words to the effect that Parliament, one can draw the inference from the fact that Parliament is withdrawing in relation not to the murder provisions, but in relation to the other provisions, drug trafficking.
Let me just clarify, Mr. Knox.
Yes.
Is there any suggestion that the judiciary cannot be trusted in relation to bail in murder cases?
No, I'm not suggesting that. No.
Is anybody else suggesting that? Or are you advancing that as part of your case?
I'm not advancing that as a justification now for the law. That's certainly not.
Yeah.
I'm simply saying at the time, Parliament itself expressed in the debates, the concern was expressed, and obviously this is reflected in the nature of the act that's eventually passed, that bail was too easily granted.
But can we take it that Parliament were fully aware that bail was not easily granted in murder cases?
Well, the only problem is it wasn't discussed in relation to murder cases.
So we have your speculation that they may have thought that they weren't changing the law in relation to murder.
I mean, the only inference one can draw is when one looks at all the debates, they're all about the extension or the extension of the prohibition of bail to other offences.
Yes.
No one is piping up saying, well, what about murder? That's, so to speak, taken as read all the way through. But the problems, there were discussions where some senators seemed to say that bail is being given too easily, or the judges or magistrates are intimidated and things like that. That was one of the drivers behind it. But it wasn't the driver behind the continuation of the prohibition of bail, as it was thought, in relation to murder. That's the position when one goes through the debates. And we do say that is obviously one of the reasons why there is a tightening up of bail against other offences. Because there is
But you're not making the case on behalf of the Attorney General for Trinidad and Tobago that the judiciary cannot be trusted.
Oh, no, I'm certainly not saying that, no.
Yeah.
Absolutely not. No, I'm not saying that at all.
Yeah.
I'm obliged, my lords. My lords, one of the points, just to cap off that point, one of the issues that arose in that debate was several requests for statistics and empirical evidence, data from the government, and the repeated cry from the contributors to that debate that no statistics were provided as to how the bail law was being administered in practice. The next document I'd like to refer my lords to would be the prison conditions document, which is at page 70 in the it's in the first supplemental bundle, sorry. I think mine is off by 1 page for some reason, sorry.
Where would you like us to go? Which page?
Page 70. I think it might be one off, so it's 69. I'm grateful, my lord. So it's Annex B, cases in which the issue of prison conditions were featured. The first one is a case of Colin Edgill, and in that case, the judge said, so severe was the treatment that this applicant endured that it can be easily held to have crossed the threshold of cruel and inhumane treatment. In the context, the remand yard in Port of Spain is a hellhole in which a man is presumed innocent, but is deprived of the elements necessary for human life: air, light, sanitation, hygiene, exercise, and even food. The level of pain and suffering inflicted during detention goes beyond the harsh, or what to my mind can conveniently be described as merely unacceptable and unsatisfactory. The treatment makes a mockery of the presumption of innocence. The board in Terence Scalick's Perlord Kerr, in paragraph 25, made reference in a report up to the Inter-American Court of Human Rights about detention in Trinidad and Tobago. The conditions at Golden Grove was described thus: cell dimensions of approximately 9 by 6 feet are shared by up to 7 or 8 prisoners. Sleeping facilities are inadequate with only 1 double bunk in each cell. Consequently, many inmates are forced to sleep on the floor on a thin piece of worn carpet, which is never cleaned, or on a thin sheet if provided by relatives.
Mr. Ramlogan, where is this taking us?
My Lord, it's just to make good the point that the prison conditions are subhuman, and to the extent that that is a relevant consideration.
I mean, I don't think it will be disputed that there are problems of overcrowding and difficulties in Trinidad and Tobago's prisons. We can't, as a court of final appeal, have cited to us gobbets from other cases where judges have made conclusions, where there's been no factual evidence led in the courts below. You can't bring this material as evidence in a court of final appeal with respect. If you're wanting us to take into account that there are understandable and serious concerns about prison conditions in Trinidad and Tobago, I don't think that is difficult. But beyond that, we can't pick any of these details out and hold them to be fact, can we?
Well, no, these are not details. These are findings made by, in some of the cases.
In different cases, not before us and not before the courts below. You're not showing me a single finding of fact that you're asking me to uphold asking the board to uphold from a court below.
No, my lord.
So I ask again, How is reciting this to us going to help us?
No, if it doesn't, I put it only to the limited extent that the board can take judicial notice of the fact that there are problems with the prison conditions, and that may be a relevant consideration to which you ought to have regard under Section 33. I take it no further, my lord.
Thank you.
I'm obliged. My lord, my learned friend made submissions yesterday. I think I've covered most of them. My lord, oh yes, my lord, there is the Daniel St. Omer case. I will give you, it's at page 1835. And in Daniel St. Omer, the challenge was to not a non-bailable offense, but rather a provision that said that if for certain crimes up to 120 days, no bail, and if the case commences within 120 days, then you can have no bail for up to 1 year. And in that case, the court did consider some of the arguments about non-bailable offences. It starts at page 1850 and it ends at page 1857. And I would just like to commend that reasoning to the board, and I shan't take it any further beyond that. My lords, in closing, my learned friend Mr. Carter will follow me and deal with the cross-appeal issue and some supplementary submissions. But we ask that the declaration of the Court of Appeal be upheld. We ask that the rights which have been which will be clarified in a written document by my learned friend, which we say would have been breached by this law, be so declared, and that the issue of an assessment of damages be referred back to the High Court for there to be an assessment, and that is the relief that we seek.
My Lord, I am taken by surprise. There is simply no, as I understand it, the issue in the Court of Appeal was deliberately restricted to one of a declaration or not. Questions of damages, assessment of damages, breaches, and so forth are simply not before this board.
No, I don't think Mr. Ramlogan is arguing it is before the court. I think he is merely asking that we uphold the Court of Appeal's remittance to the High Court for the question of damages to be determined if we are with the respondent,
and whether there is to be
clearly whether there is to be the question of damages, the vindicatory damages, the whole question whether there should be, and if so, the quantum of would be a matter for the High Court, not for the board.
Yes, thank you.
Much obliged, my lord. Thank you, my lord.
Thank you very much, Mr. Ramlogan. Yes.
I hate, my lords, to start by contradicting my learned leader, but I'm going to by saying that I do not intend to address your lordships about the interested party submissions. I'm going to let Mr. Mendes speak for himself.
I'm grateful the interested party is here and can address us. What are you covering then?
Can I start? What I intend to deal with is pick up a point that was by way of an intervention by my Lord Stevens, which was then picked up by my Lord Burrows, about the extent to which... Yes, of course.
Is this cutting into...
Here we go.
Which time? We're cutting against the timetable here, aren't we?
The appellant set into 10 minutes of their reply.
Yes, sorry, my lord. About the extent of the concession being made by the appellants as to the degree to the extent to which the Bail Act extended beyond existing law. And I confess I'm not entirely clear of the extent to which Mr. Knox was accepting that the Bail Act did go beyond existing law. He seemed to accept that the High Court had jurisdiction pre-committal. But at one stage he was arguing that the High Court had no jurisdiction post-committal. But then I understood him to resile from that but I'm not entirely sure where we stand on this. And so if necessary, unless I'm knocking at an open door, what I was proposing to start with was by providing substance to support what my Lord Stevens said as to the interpretation that he suggested to Mr. Knox as to the appropriate interpretation of section 27(1)(c) and how that applied to the power of the judiciary, the discretion of the judiciary to grant bail, to the extent to which it applied pre- and post-committal, and even could extend post-conviction. So, as I say, unless I'm able to be told that my Lord Stevens' intervention has become effectively an agreed basis for the board, then in order to avoid silence being interpreted.
Well, my understanding is that the Attorney General has not conceded that there is any innovation in the Bail Act in relation to post-committal bail.
That's right, yes. We say the effect of the the effect of the Indictment Offences Act, section 27C and D, was that post-committal or upon and after committal, there was no power in the High Court to grant bail.
Yes.
There may be, one can imagine, special cases which might come up under the existing Act and as well as under the old Act. When, for instance, there's a change in the evidence, or someone comes back and says there was a lie told by someone. But, my lords, that we say whatever the position it was then is now. But the basic position is once you've been committed for trial, then bail cannot be granted.
That is the Attorney General's position. That's what I understood it to be. You have 8 minutes to make your submission.
Well, there have been further interventions by the appellant, I have to say, my lord.
You have 8 minutes to make your submission.
My submission, my lord, is this. That is a very unsatisfactory state of affairs. For the appellant to say that there is a residual discretion in the court to intervene in cases where he cannot say where that residual discretion is found if it is not a general discretion to grant bail in all cases, both pre- and post-committal. Because what he says is that there is an opportunity for an appellant in exceptional cases to apply to the court for what? The Bail Act prohibits an application for bail.
Well, that is the short point, isn't it?
That's the short point.
Yes.
So any application to the court would be, well, that's where we are now.
How can there be a residual power in the face of the wording of the Bail Act?
My lord, precisely. And what he suggests is that we are perfectly entitled to be exactly where we are now, pointing out that the Bail Act does not represent saved law, existing law, and seeking to have a confirmation that the saved law, the existing law, the High Court had jurisdiction to grant bail, albeit it would only do so in practice in rare cases, but it had jurisdiction to grant bail at any stage of the criminal proceedings. And that is entirely in accordance with the English common law.
Well, we saw that from Mr. Ramlogan's submissions.
And the difference was that the 1917 ordinance deprived the magistrates of granting bail in murder cases and one or two other cases, but did no more than that. And interestingly, Mr. Knox was invited at some stage to assist with English criminal law, and understandably he was not able to do so, and I don't blame him for that at all. It's not his area of practice. But I can, because the English criminal law now does prohibit magistrates from granting bail in murder cases, but it's subject to an immediate, within 3 or 4 days, application or appearance before a Crown Court judge, at which the issue of bail will be considered. And that's significant for two things, partly for an explanation of where the law is in England, and also it may be said that it goes to the Section 13 point, as to whether a very limited prohibition on the power of the lower judiciary to grant bail is in accordance with the standards to be expected of a democratic state, but no more than that. So, my Lord, your Lordships will remember that the history of what is now Section 27(1)(c) or 29(1)(c) originally included the words bailable or if such offence be not bailable. And those words were repealed by the 1962 ordinance. And so therefore, the extent to which they ever had any effect had ceased to be applicable by the time of the Constitution.
Yes, but it is not the key point that what was Section 31 of the 1917 ordinance, which relates to the power of the High Court, remained the law up to the 1976 Constitution.
That's the key point.
Yes. I mean, do we need to go into the details of the magistrate's power at all? Because the High Court had a jurisdiction to grant bail at any time on the petition of the accused in respect of any offence.
My Lord, I absolutely agree. It's just the case for the appellant is that the words bailable and or not bailable indicated a restriction on the power of the High Court.
Yes.
That otherwise applied, and I suggest he can't rely upon that.
Yeah, but I think we have the point from Mr. Ramlogan that bailable, non-bailable was a reference to the magistrate's powers.
Yes.
And had nothing to do with Section 31.
And as my Lord Stevens has said, that the other provision, the proviso, that if the case had not come on for trial, then the court could grant bail, other than in murder cases and so on, did not affect the power of the right of the High Court one iota. And so I simply make that point.
Yes.
And by way of illustration, my Lord, since the Bail Act, the Bail Act of 1976 in the English Bail Act, for the first time actually set out as a statutory basis the grounds upon which bail could be allowed. It didn't expressly include delay. So to that extent, Trinidad, in allowing other than in cases of murder, treason and piracy, Trinidad, in allowing judges to be able to use something which English courts couldn't use as a ground for bail, was in advance of English law. And it wasn't until several years later that the custody time limit procedure allowed courts to take into account failure by the prosecution to conduct the prosecution diligently and effectively within a prescribed time.
I'd be extremely surprised if that factor wasn't present at common law prior to any statutory provision.
There were occasionally appeals which went to the Court of Appeal on the basis of delay, on the basis that it deprived the defendant of a fair trial. But it wasn't on the issue of bail. They were on the issues of the fairness of the trial. So it might be said that under the Bail Act Schedule 1...
It's always been the position that if you've almost time served on remand,
yes,
that you have an automatic right to bail. And so prosecution delay, have always perceived to be a factor.
It has, my Lord, because Schedule 1 of the Bail Act said that the court should have regard to some certain prescribed circumstances, but also has a residual ground, any other consideration which the court regards as relevant, and that would allow for delay. But it wasn't an explicit ground for granting bail, which is why I say that the Trinidad ordinance was unusual and was in advance of UK law. And that's why, my Lord Stevens, I agree with your interpretation of it, as did the Court of Appeal, that this was giving an extended power to grant bail in non-murder cases and did not affect one iota the existing jurisdiction of the courts to grant bail in any category of case, including murder, at any stage of the criminal proceedings.
I was just thinking in terms of existing common law and its incorporation as far as bail is concerned. The grounds for opposing bail is the person won't turn up for trial, will commit offences. There are lots of individual facts you take into account in forming an assessment of those.
Yes.
It's a discretion, and the factors influencing that discretion have always changed over time. One can't put an aspic the various discretionary factors set out in Archbold, because, for instance, you didn't have ankle tags in that time. So,
there are all sorts of reasons why, evidentially, case by case, what might give rise to a fear that the person wouldn't attend can be rebutted, or the risk can be reduced to a level where it is acceptable. But that, as my lord says, it depends upon technology available and changes in circumstances and changes in lifestyles. And also, there are occasions when the prison population becomes such that there is an imperative that wherever possible, bail should be granted, whereas in other circumstances, judges may have been a little wary of taking the risk in an individual case. But these are all things which are part of judicial discretion day by day. Every day, these decisions are being made by courts around the world. But in murder cases in Trinidad, they are not. And that's the mischief. And it is such a substantial mischief that it does not fall within what is justifiable in a society which has proper regard for the rights of individuals. I think, my lord, my 8 minutes are up.
Thank you very much. Mr. Mendes, you'll need to speak from the microphone.
Thank you very much, my lord, and thank you very much for Mr. Knox for allowing me to intrude on his space. Although I'm sure he'll forgive me if I do not repay his hospitality by agreeing with everything that he has said. And there are some things in respect of which we are, at the Law Association, is in disagreement with the Attorney General. Now, if I may address one point, and that is the question of the applicability of the presumption of innocence. That is dealt with in the Pearson case by the Supreme Court of Canada. And you will see the court dealing with that at electronic page numbers 1806 to 1813. And in summary, the court takes the position that the right to be presumed innocent and the right to bail are parallel rights, and that in effect, the right to bail gives effect to the presumption of innocence at that stage of the proceedings, so that it is not necessary to engage in a separate analysis of whether the right to be presumed innocent is infringed. You need only to examine the question whether the right to obtain reasonable bail without, and not to be deprived of it without just cause, has been violated. And that is essentially the position taken by the Supreme Court of Canada. If we may be allowed to spend a little time on the question which has arisen concerning the exact test to be applied under Section 13 of the Constitution, and to offer the Law Association's view in that regard. And I think that
I'm grateful for that, Mr. Mendes. It seems, at least to me, that is the central issue of this appeal.
It has turned out to be, yes, my lord. If I may, I think we will have to start by looking at Section 5 of the Constitution, first of all, which you will see at electronic bundle page number 1421. And Section 5.1 says, except as is otherwise expressly provided in this chapter and in Section 54, no law may abrogate, abridge, infringe, etc., any of the fundamental rights and freedoms. And then 2 says, without prejudice to subsection 1, but subject to this chapter and to Section 54, Parliament may not do the things that are there listed. So that what Section 5 is doing is prohibiting Parliament from doing certain things and prohibiting laws, generally speaking, from abrogating fundamental rights, but there's an exception created to that prohibition. So Section 5 basically is protecting the fundamental rights and freedoms guaranteed by the Constitution under Section 4, but is creating an exception to that. One of those exceptions, of course, is contained in Section 13. There are other exceptions in the chapter that is referred to, for example, passing laws when there's a state of emergency. But the one that we are concerned with is the exception under Section 13. Now, because Section 13 is an exception to the protection of fundamental rights and freedoms, it, like other exceptions, must be interpreted narrowly, we would respectfully submit in the first place. And that, of course, I think has consequences for the approach that the court ought to take to exactly what it is that Section 13.1 is permitting the legislature to do. And Section 13.1 then reads, an act to which this section applies, and of course we know what that act is by the subsections below. It is an act that has been passed with a 3/5 majority. So basically an act which has been passed with a 3/5 majority may expressly declare that it shall have effect, even though inconsistent with Section 4 and 5. And if any such act does so declare, it shall have effect accordingly. So that the preconditions to the act having effect, even though inconsistent with the Constitution, are two manner and form or procedural conditions. One, the special majority, and secondly, the declaration in the act itself that it is inconsistent with the with sections 4 and 5. But the latter condition is the important one, because the section doesn't stop there. It doesn't say that the act has effect as long as you meet these two procedural conditions. It goes on to say, unless the act is shown not to be reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. So that this is to be read, essentially, it shall not have effect if it is shown not to be reasonably justifiable in a society. It has to be read in that way. So that read in that way, it is not giving the legislature carte blanche to override fundamental rights and freedoms simply by obtaining a special majority and putting in a declaration. It only overrides the fundamental rights and freedoms if it is not shown to be reasonably justifiable and so on. And of course, I agree with my learned friend, Mr. Ram Logan, that what this section does is to place a fundamental duty on the judiciary to make that determination, so that the judiciary becomes expressly the protector of the fundamental rights and freedoms in circumstances where the ruling party happens to persuade a sufficient number of members of the opposition or of the independent bench in the Senate to side with it in passing legislation.
It's not quite a protection of the fundamental rights and freedoms. The judiciary is there to uphold the Constitution.
Absolutely.
And to decide whether or not the departure or the inconsistency with those fundamental rights and freedoms is or is not reasonably justifiable in a society which has proper respect for the rights and freedoms of the individual.
Yes.
Yes, which is it's not quite the same thing. Because you are departing from, the starting point is there is a departure from those rights authorized by the Constitution, and one then has to look to see whether or not such a departure is reasonably justifiable.
But that departure has no effect. It does not have any effect in law unless it is a departure that is in fact reasonably justifiable, or put it negatively.
It has an effect.
It does not have effect.
No, it does have an effect in law. It has effect in law immediately. But if it's challenged, then the court has to ask, is this departure reasonably justifiable?
But the condition in any event, whether it is determined ex post facto or not, the condition of the law having effect as part of the law, despite the fact that fundamental rights are being infringed, is a determination by the judiciary that it, agreeing with the complainant, that it has been shown not to be reasonably justifiable. Now, all I am saying, my lord, is that there isn't anything, it is not possible to read into this section as it is. First of all, reading it narrowly, that there is obviously a certain level of deference that must be paid by the court to the legislature's judgment. I respectfully agree that in making the determination what is reasonably justifiable, and that is an objective test, the court will apply a test that ensures that the judiciary doesn't apply their own personal predilections. So an objective test is necessary in the first place. And in working out that test, as courts have done in applying similar provisions, there is room for taking into account the legislature's view. And indeed, that is what the proportionality test does. And we are respectfully submitting that it is not necessary to go beyond that test to as it were, establish a separate consideration of deference to the legislature. All of that is, first of all, it works out, or the legislature's view is protected because the onus is placed on the person who is challenging the legislation to establish that it is not reasonably justifiable. So that presumably, if the court is not certain, or if the court is in doubt as to whether it is not reasonably justifiable, the court will not strike down the legislation, so that the legislature's view is given due respect in that regard. And similarly, when we look at the proportionality test, the legislature's view on the legislation, how it is to be balanced against the public interest, the violations against the public interest, in working that out, the legislature's view will be taken into account. But there's no need to say that there's some extra deference that ought to be paid to the legislature's view in working out what is reasonably justifiable. So if we, for example, look at how the test operates, and this is the Bank Melat test, you'll find at electronic bundle page 1930, which is the judgment of Lord Sumption. And at the top of that page, just below letter A, he is summarizing the developments in the law since the Freitas. And he says that their effect can be sufficiently summarized for present purposes by saying that the question depends on an exacting analysis of the factual case advanced in defense of the measure in order to determine, one, whether its objective is sufficiently important to justify the limitation of a fundamental right. So, in doing so, the court must first of all establish what is the objective, what is the objective that the particular measure is seeking to achieve. And that has to be identified, I imagine, as a matter of fact. If, of course, the court finds that the objective is not sufficiently important to justify the limitation of a fundamental right, then it can't possibly be reasonably justifiable in a society that has proper respect for rights and freedoms. You simply can't go any further. If you establish that the objective is not important at all, it's trivial. I'm not suggesting that the objective in this case is trivial, but I'm saying that the test is valuable in seeking to determine whether the measure is reasonably justifiable, because when we look at the first gate that you have to open to get through, obviously, if the objective is not sufficiently important, it can't possibly be reasonably justifiable. In this regard, it is, my learned friend Mr. Knox has referred to some parts of the debates in Parliament on the bail bill to assist the court in determining exactly what the objective was. in our submissions, we assumed that the objective of this particular piece of legislation was to ensure that persons accused of murder turn up for trial. We assumed that that was the objective. The suggestion seems to be that the objective may have been to deal with the surge in crime. But if you look at what the Attorney General has said, this is at electronic bundle page number 3397.
3397.
3397. And he has just gone through the history of the various drafts that had been put up for public comment, leading eventually to this version of the Bail Act. And in the fourth paragraph down from the top, he says, "We must understand as well that whilst the underlying principle behind the system of bail is that there is a judicial determination, our existing law recognizes that there are circumstances under which the judicial discretion will be removed. I refer specifically to instances of murder and treason, where a person only has to be charged, does not have to be convicted. With those two offenses, and the existing law says that he would not be granted bail."
Well, that seems to be, on one view, proceeding on a mistaken view of the law.
Precisely. So that one may say that there was no objective at all. The legislature thought that it was simply reflecting what the law was already was. But then Mr. Robinson, who later on became Prime Minister, asked the question, "Madam Speaker, will the Attorney General also state the reason for that?" And the Attorney General says, "Madam Speaker, I think the Honourable Member for Tobago East, the reason bail was not granted was primarily that one considered that those offences were of such an offensive and heinous nature that bail ought not to be extended." So is that the objective that is being sought to be achieved by, in the Attorney General's mind, incorporating what he thought the law already was into this provision of the Act, which essentially was to punish persons who are charged for crime, not to ensure that they turn up for their trial, but simply because the offense is an offensive one and of one of a heinous nature, and therefore you don't get bail for it at all.
I'm sorry, I'm just a little bit troubled. To what extent is it appropriate for us to look at these extracts as a basis for inferring
My Lord,
the object of the legislation, the objective of the legislation?
My Lord, I agree. I'm referring to it because my learned friend has put it before the board to assist the board in understanding what was behind the legislation. Remember, it was his submission that we have to find out what was happening in 1994 when the legislation was passed.
If Mr. Knox, making submissions for the Attorney General, was saying that the purpose of the legislation was treating murder and treason as being in the bag, as non-bailable, extending it to other serious crimes, then the overall purpose of the legislation was surely the prevention of crime and disorder. So that in itself is a legitimate aim. But the point that I think Mr. Logan was making is that the Parliament may have acted on a completely incorrect basis of law and have removed a discretion which existed without knowing they were doing so.
It seems so.
Yes.
But to the extent that a relevant question in determining the reasonable justifiability point is what was the purpose of the legislation in the first place.
And the purpose of the legislation was to extend the prohibition of bail.
Well,
of this provision.
My Lord, the fact is that this was not explored in evidence.
Yeah.
In the court below. We were handed these extracts from Hansard before the board, and my learned friend Mr. Knox is putting his interpretation on what the government thought the purpose of the legislation was. Now, it may be, as the other parts of the debate indicate, that the intention to deal with the surge in crime was the purpose of other provisions of the Bail Act. But as far as this provision is concerned, and this is the only one that we are concerned with, this is what the Attorney General has said. Now, I'm making the point, my Lord, as well, that as far as the Supreme Court paying deference to the view of the legislature, we have this problem to deal with where the Attorney General, to whom we are considering whether deference should be paid, is saying that the reason for this provision is because murder is a heinous crime. Not that we would wish to ensure that persons charged with murder turn up for their trial, but simply to punish them for being charged with a heinous crime. And I'm saying that is the danger of saying that we will simply defer to the legislature as to the purpose for which the legislation is to serve. And yes, I would respectfully agree. There's a limited degree to which we can rely on these statements in any event in order to determine whether the legislation is...
Again, I mean, I doubt we can rely on it because the Attorney General's answer relates to his understanding of what the existing justification was for the absence of a discretion. And the case, as I understand the respondent is, one of the cases the respondent is presenting, is there wasn't an absence of discretion. There was a removal of that discretion by this Act.
In which case, my Lord, we cannot put any stock in what has been put forward as the purpose of this legislation, at least not on the basis of the material that has been put before the board. The Law Association is happy to approach an analysis of this case on the basis that the real reason was to ensure the persons charged with murder turn up for their trial, because that is certainly a legitimate objective of legislation of this sort. And although we did not put this in our written case, we are also prepared to accept that a legitimate objective of denying bail to anyone who is charged with any offense for that matter, well, let's say serious offenses, is to ensure that they don't commit any further crimes. So we accept whatever the Attorney General may have said, whatever he may have thought, that could be a legitimate purpose for the legislation. The point I'm making, though, ultimately, in working out exactly how the reasonable justifiability test is to be applied, is that certainly this aspect of the proportionality test is useful in assisting the court in making that determination. And that's essentially the point that I wanted to make. But before I leave this aspect of the case, that is to say, exactly what was happening in 1994, my learned friend, Mr. Knox, seemed to make a lot about who and what was being said in opposition to the legislation at that point in time. And he was saying that the Law Association was silent. Of course, there is nothing in the material that says what the Law Association was saying at that point in time, so that there's an absence of evidence of what the Law Association said or did not say. But of course, that is not evidence that, in fact, the Law Association said nothing. And indeed,
we are not here as a court of final appeal to look at the evidence or absence of evidence on issues
I would have thought so,
for the first time.
I would have thought so, my Lord. But to the extent that you were troubled at all by what my learned friend Mr. Knox has said, the Hansard, the full Hansard has been put before you in a supplemental record, which shows that in other parts of the debate in the Senate, that references are made to a number of persons, including the Law Association, making submissions in relation to the earlier versions of the Bail Act, that is to say the 1988 versions, but not in relation to the 1994 version, because that was not sent out for public comment. But in any event, I don't know to what extent that the learned friend intended you to take these things into account, but certainly the record does indicate that there was objection to the 1994 Bail Act. The Attorney General himself mentions submissions made by an organization called the Coalition for Social Justice and Human Rights. And I know that organization quite well because I was the president of it at that point in time. and I authored the objection to the 1994 bill. So that there were objections being made to the 1994 bill. As I say, I don't know to what extent that this can assist the court, the board at all, in resolving these issues, but so it is.
I, for one, don't think this legislative history will assist the court, and unless my colleagues think otherwise, I think we should move on to work our way through the 4 Bank-Mellat criteria.
Thank you very much, Milo. The second test, the proportionality test, is whether it is rationally connected to the objective. So, my Lord, again, if you establish that the objective is to ensure that people turn up for trial or to prevent crime, but the measure is determined not to be rationally connected to that objective, then again, it can't be reasonably justifiable. Because essentially you're taking away fundamental rights and freedoms, and you are not achieving your objective. And if that is the case, it can't be reasonably justifiable. And similarly, 3...
Well, I had difficulty with that. I mean, if the legitimate aim, I'd always understood, and Mr. Knox is no doubt going to help us, I thought the legitimate aim was prevention of crime and disorder.
Yes.
And, but if the legitimate aim is to ensure people turn up for trial, then incarcerating them achieves that aim.
And that is, in fact, what we submitted as well. We accepted in our written submissions that if that was the aim, then certainly if you incarcerate people, then you're fairly certain, unless they escape, of course, you'd be fairly certain that they would turn up for trial.
And if the legitimate aim is the prevention of crime and disorder, that, in one sense, assumes that the applicant for bail is guilty of an offence, because he is, you're relying upon the fact that he's committed an offence. And unless there's other evidence of other crimes of which he's been convicted in the past.
Yes, you're assuming that because police think that there's sufficient evidence to support the charge, that person automatically will commit another offence, so that goes against the presumption of innocence.
Well, another offence, the word another offence, means that he is guilty of this offence.
That's correct. So that the point I'm making, though, my Lord, is I'm making 2 points. One is that this test is relevant to the question of the reasonable justifiability test under Section 13, but applied to this case, if the legitimate objective is to ensure that the person turns up for trial, then it will be met, or there's a rational connection between prohibiting bail and that objective. If the legitimate objective is to prevent crime, then, as my Lord has pointed out earlier, well, what's the point of passing this law when, in any event, the judiciary was exercising their discretion properly to ensure that persons turn up for trial? And certainly if they denied bail to persons charged with murder, by and large, or customarily, then the objective is being achieved in any event. So that you are depriving that exceptional case of a right to bail unnecessarily, because there is no need to implement this measure at all. But the third criteria, whether a less intrusive measure could have been used, we respectfully say that you simply allow the judiciary to do their job. That is less intrusive. Certainly it would not intrude at all upon the rights of the deserving person who, for whatever reason, is able to establish to the court that they will turn up for trial, they will not interfere with witnesses, they will not commit other crimes, and so on. And in the case, or in a case where the person is denied bail initially, and there is a long delay and the trial is simply not coming up, then you get an opportunity to go back to the court to say, well, what's happening here? I am being deprived of my liberty, and there's no chance at all that I can get a trial to prove my innocence. The point is that if you leave it to the judiciary to consider the various circumstances in which the question of bail might arise, and not put this blanket prohibition against bail, you will achieve your objective in any way, in any event.
Whatever it
Therefore,
is, however you characterize it in terms of the various options you've laid in front of us,
yes,
you would say it is met in any event
that's
by
correct.
leaving it to the judiciary.
That's right. In any event, it is met by leaving it to the judiciary. But I'm making, again, 2 points. One, this particular measure does not meet the proportionality test, but I'm also saying that the proportionality test assists the court in determining whether it is reasonably justifiable. And of course, the last one is the catch-all, as it were, is whether, having regard to these matters and the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. Again, that is a balancing act that the court will have to engage in. But is in this regard, and I should say in all aspects of the proportionality test, the court will be taking into account the views that have been expressed by the legislature as to the need for this particular measure. And I'm respectfully submitting there is no need to give any further deference to the legislature, particularly since the onus is on the person who is complaining to establish that it is not reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual.
Thank you.
Now, on this, my lord, there's one further point I would wish to make. My learned friend, Mr. Knox, has recommended the approach taken by Justice Georges, a renowned jurist in the Caribbean, in the Robinson and Seeley case, and in particular, page 3034, where Justice Georges had adopted what had been said by Chief Justice Shastri in the state of Madras against Rao case. That's electronic bundle 3034. And this is what Chief Justice Shastri said. The court should consider not only factors such as the duration and the extent of the restrictions, but also the circumstances under which and the manner in which their imposition has been authorized. The nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied thereby, the disproportion of the impositions, the prevailing conditions at the time, should all enter into the judicial verdict. My lords, I respectfully submit that that is just the proportionality test. Maybe not as organized as well as it has been organized in De Freitas and in Bank Melat, but it is more or less the same considerations that you would take into account in determining whether a measure is reasonably justifiable. So we respectfully submit, my lord, one, that in accordance with the position that the Court of Appeal has taken in the Francis case and in the Northern Construction case, that the proportionality test is a useful tool to assist the court in determining whether a measure is reasonably justifiable. May not be the only test. There may be circumstances in which there are other factors that you would rely on. It depends on the circumstances of the case. But respectfully submit, certainly, that if the proportionality test is not met in any particular case, it's difficult to conceive of circumstances where it will nevertheless be held to be reasonably justifiable. And so we would recommend that the court uphold what the Court of Appeal has said in relation to the proportionality test. Now, my lords, if this court finds that in agreement with the Court of Appeal that Section 5 is not reasonably justifiable, then in accordance with Section 13, it does not have effect as part of the law. And it will fall to the court, subject to the Savings Law Clause in Section 6, which I'll come to in a moment, But it will fall to the court to determine what to do about Section 5, having regard to the Supreme Law Clause in Section 2, which says that any law that's inconsistent with the Constitution is void to the extent of the inconsistency. And we respectfully submit that in applying Section 2, it is very easy just simply to sever the latter part of Section 5, that is to say, that part which refers to except those offenses listed in the first schedule. And then Section 5.1 will simply read that a court may grant bail to any person charged with any offense. And of course, the remainder of the Act would then apply, which governs the various factors that one would have to take into account in determining whether to grant bail. Now, the effect of that is to ask you, my lords, to depart from what the Court of Appeal has done, because what they did is not to just simply sever the latter part of the section, but to say that it is inconsistent insofar as it prohibits the High Court from granting bail in a case of murder. So they limited the inconsistency to the prohibition against High Court judges, which means that a magistrate cannot grant bail in accordance with, for murder in accordance with Section 5, and as well masters cannot grant bail. Masters now, my lord, in accordance with the current law in Trinidad and Tobago, are being appointed essentially to play a subordinate role to High Court judges in the administration of criminal justice at the level of the High Court. So masters are being given a number of different functions to assist judges, and one of the things is to grant bail. And the effect of Section 5 as well will be, the order that the Court of Appeal has made is that masters and magistrates cannot grant bail for murder.
But they couldn't grant bail, could they, for murder as a matter of existing law before 1962 or 1976?
That is so, and this is why I'm coming to the next point, is to whether Section 6 applies. I'll come to that in a moment. But the importance of the point is this, that as the law currently stands, if you go to a High Court judge directly in accordance with the order of the Court of Appeal, and the High Court judge either grants or refuses bail, that's the end of it. There's no appeal to the Court of Appeal. So if you're denied bail, you're stuck with that. If you were granted bail and the prosecution does not agree, then you are stuck with that. The prosecution cannot appeal either. On the other hand, in accordance with the way the Bail Act operates, if you go to the magistrate first, and that applies in relation to all the other offenses that magistrates can grant bail in relation to, if you're dissatisfied with the magistrate's order, you can go to the High Court judge. And if you're dissatisfied with the High Court judge's order, you go to the Court of Appeal. So it is very important to know, very important certainly for the administration of the bail system, that magistrates also have the power to grant bail or refuse it, as the case may be, because then you have access, both the prosecution and defense, you have access to the High Court, and you also have access to the Court of Appeal.
But have magistrates or masters ever had that power in relation to murder in Trinidad and Tobago?
Well, certainly not since 1917. I can't answer whether any time before. I suspect not.
No.
But this is why I'm saying that I'm indicating the importance of the point first of all, and then I'm going to answer the question, does Section 6 save the law that existed prior to 1976, which said that magistrates could not grant bail?
Well, before we get to the saving clause, I mean, would you not have to establish that it was unconstitutional for there to be a law which confined the grant of bail for murder to High Court judges? Would you not have to establish that first? And where's your case on that point?
To confine it to High Court judges? Yes. Well, my Lord, I'm focusing on the law that says that you can't get bail for murder from any judge.
No.
And more than that, sorry?
No, but you were going on to say, you were asking us to depart from the Court of Appeal which merely limited the removal of the prohibition to the extent of High Court judges.
My Lord, the Constitution says that when you are charged with an offence, that you are entitled to be brought promptly before an appropriate judicial officer.
Yes.
It doesn't. So that is so once you're charged, you go before an appropriate judicial officer. It doesn't say the High Court.
No, but are you saying it is contrary to the Constitution for the law of Trinidad and Tobago to confine the right to grant bail to High Court judges? And if you are saying that, on what basis are you saying it?
Well, my Lord, the law of Trinidad and Tobago did not confine it to High Court, the grant of bail to High Court judges. It said no one could grant bail. So we're dealing with a provision that says that you cannot get bail from anyone.
Well, after the Bail Act was passed, yes.
Yes, and that is the provision that is under challenge. We respectfully submitting.
But you'd have to establish, would you not, that it would be unconstitutional to confine the grant of bail to High Court judges.
I'm saying, my Lord, that I'm saying not necessarily, and I'm saying not necessarily because we are dealing with a provision in the first instance that didn't confine it to High Court judges, that it was a blanket prohibition against the grant of bail. That prohibition, blanket prohibition against the grant of bail, violates the right to reasonable bail, more particularly since the first appropriate judicial officer that you go before is a magistrate, and that judicial officer cannot grant you bail. Of course, the whole idea behind a provision that you be taken promptly before a judicial officer is that that judicial officer can make a determination as to whether you should be remanded or not, whether you should be free or not. And if a law says that no one can grant bail to you, then your right to reasonable bail is violated as soon as you are arrested, and it's violated even the right to a procedural provision to give effect to your right to bail is violated when you go before a judicial officer who says, well, there's nothing I can do about it. So the rights are violated at that point. And therefore, we are respectfully saying that this court is considering is that blanket prohibition against the granting of bail in violation of the Constitution. If it is, and it is conceded, then is it reasonably justifiable in a society, etc., etc.? We're respectfully submitting it is not. If that is the conclusion, the question is what is the appropriate order to make?
Could you bring me to the constitutional provision that sets out the appropriate order that can be made? Obviously, severing is one of them. But what is the actual constitutional provision? Because if you do sever out of the Bail Act, Section 5,
yes,
the offence of murder, then it's open to a magistrate to grant bail in relation to murder. So, but the Court of Appeal didn't do that. They did something differently. And I was just wondering what the constitutional power is.
The constitutional power resides in Section 2,
right,
which says that a law which is inconsistent with the Constitution is void to the extent of the inconsistency. And what the courts have done is to interpret that provision as giving it power to lop off, as it were, the unconstitutional parts, as long as what remains is a coherent whole. And we have referred the court to the learning going back to the 1960s in the, I forget the name of the case now, but certainly it was considered and developed recently by the Caribbean Court of Justice in the Zuniga case. Essentially, the court has the power in the circumstances to do some surgery on the legislation to take out the unconstitutional parts.
It could make a declaration as to what the law is. It isn't confined to lopping off. So
no, it isn't. You could make a declaration and stop short.
And if there's no protection for the provision by existing law, then isn't there a power of modification in the Constitution of the Trinidad and Tobago Act?
Yes.
Yes. So the court can modify.
As well.
Yes, the court can modify as well. You don't,
Yes.
you don't just look at the Constitution, you look at the act that created the Constitution, and there you find the power of modification.
That's correct. If it is an existing law, that is, if
It's an existing law.
it is an existing law, then the modification power applies. But if it is not an
existing law, then there's no modification.
there's no modification power.
So you're
The
right.
only power you have is the power under Section 2 to
So it's just the
declare
Section
void.
2 power. Yeah.
Yes.
Sorry, you're right.
So that
So if it declared void the whole of Section 5.1, insofar as it related to murder,
yes,
then the existing law would be Section 34 of the 1917 Act.
if yes, but if it did, yes.
Yes. Yeah.
But what I'm saying, my lord, is that the surgery that could be done is simply to take out that part that refers to murder. And the law would then read that a court would have the power to grant bail. And the court there includes a magistrate.
Yeah. But the difficulty with that is it's perfectly permissible to have different judicial tiers dealing with different levels of severity of offences, seriousness of offences.
That is so.
And there's nothing constitutionally invalid with that.
Except, my lord, that the Constitution is saying that you must be brought promptly before an appropriate judicial officer.
Right. But you're brought before a magistrate, and the magistrate no doubt can advise you about your right to apply for bail to the High Court.
That is indeed so, my lord. But in the context where the Constitution is envisaging that you be brought promptly before an appropriate judicial officer, not the High Court, precisely so that the question of bail can be dealt with, and in the context where magistrates customarily deal with, or it is a magistrate that you're brought before, a law that then prohibits everyone, including the magistrate, to grant bail would be in violation of the Constitution and respectfully submit not reasonably justifiable.
But isn't the if we're against you, against you in relation to this being something within the jurisdiction of a magistrate,
yes,
what's wrong with the declaration that was made by the Court of Appeal?
then there's nothing wrong with it.
Yeah.
But this is why our challenge is only in relation to the failure of the court to go further and to declare it inconsistent insofar as it relates to masters and magistrates as well.
We'd be taking on a legislative power.
Sorry, Madam?
We would be taking on a legislative power because we would be, contrary to all the rules, all the law in Trinidad and Tobago, we would now be enabling magistrates to grant bail for murder.
Yes, that is to say, contrary to what the legislature has done in the past, but the section has said that a court has the power to grant bail. And if that is an unconstitutional, that no court may grant bail in relation to murder, and if that is an unconstitutional provision, then you do have the power under Section 2 to sever the unconstitutional power.
Mr. Knox says that there's also a power under Section 6.2 that might be applicable here because presumably on the basis that the Bail Act repealed the prior provisions in relation to bail and reenacted with modifications the rules of bail.
Yes.
And in that context, the legal rule is that you substitute the provisions of the existing law. And on one argument, that is what the Court of Appeal in its declaration was seeking to do.
Yes.
Do you accept that Section 6.2 is relevant here?
We respectfully submit no, and we have dealt with that in our written submissions, but if I may say why, and it's a very simple point, my lord. First of all, I understand my learned friend, or at least I don't understand my learned friend to be saying that the Section 5 of the Bail Act is protected by Section 6.1. In other words, I don't understand him to be saying that Section 5 is an existing law, either under 6.1a, b, or c. Am I right?
Because I accept there was a jurisdiction in the High Court to grant bail before, that I cannot say that to totality of Section 5 is an existing law. It's only an existing law to the extent that it prohibits the grant of bail.
Yes. But Section 6.2 is concerned with the situation where there is some derogation, and it's a striking down of the extent of the provision, so far as it has exceeded the existing law. So, is it your position, Mr. Knox, that Section 6.2 still applies to Section 5?
Absolutely. Yes. Our position is very much we rely on Section 6.2 to save what you might call the good part or the existing part. Section 5, yeah.
Which is would be at least the prohibition of magistrates and masters, and you would also say post-committal. Yes.
Yes. So that I was just making it clear, so I understand him not to be relying on Section 6.1. He's relying on Section 6.2 only.
Yes.
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 So that the question.
My question was, do you consider that Section 6.2 is relevant in this context? That if there were elements of the existing law reenacted in Section 6.5, which offended Section 13, then the provisions of the existing law would be substituted for those for the offending words in the enactment.
We respectfully submit, my lord, that Section 6.2 does not apply, and I'll give you the reasons why we say that. Now, first of all, if I may put it this way, the law which existed, as opposed to the existing law, the law which existed prior to 1976 was a law, if, my lord, you agree with our submissions and the submissions put forward by the appellant, was that bail for murder could not be granted by a magistrate, but could be granted by the High Court, either both pre and post-committal. So that was the law which existed. The enactment that Section 6.2 is directing your attention to, of course, is Section 5, which now says that you can't get bail from anyone at all. So that the enactment that is referred to in the first three words is Section 5, really. So it says, yes, where an enactment repeals and reenacts with modifications an existing law. So the question is, does Section 5 repeal and reenact with modifications an existing law? We respectfully submit, first of all, that that phrase must be construed narrowly, not generously, because it is a derogation from fundamental rights and freedoms, because it is now upholding something that might be unconstitutional. So has Section 5 repealed and reenacted with modifications? We respectfully submit that what Section 5 has done is not to repeal and reenact, but obliterate the law that had existed in 1976, which was you could get bail from a High Court judge. It is too much to say that there was simply a modification of the existing law when what you have done is to prevent an accused from getting bail from the High Court. You've changed the common law entirely. You have removed a very significant provision in Section 3, or 33, of the Indictable Offences Preliminary Inquiry Act. So you haven't simply reenacted it with modifications. It has done away with bail altogether, and therefore we say that you don't get to consider the rest of Section 2 because the first part of it simply doesn't apply. But of course,
well, but then presumably one would strike down the whole of Section 5 then.
No, my lord, because if you strike down the whole of Section 5, you'll be striking down those parts that gives the court or deals with the court's power to grant bail in relation to other offenses, besides murder and treason. So what you do is you strike out the exception because it is granting, Section 5 is granting
But
the court.
we'd then be legislating to innovate on the bail regime of Trinidad and Tobago.
My Lord,
Because Parliament never intended to give magistrates and masters the power to grant bail for murder.
My Lord,
You're wanting to get by a side wind a liberalising reform of the law of bail.
My Lord, in the jurisprudence dealing with the exercise of the court's power to strike down unconstitutional laws does include that element, that the court must ensure that what it is leaving behind is what the legislature intended, so that is a consideration. Again, I think the passages that we've referred to in our written submissions probably point to that. I don't recall at the moment, but certainly within the learning there is that. But as far as assessing exactly what the legislature's intention is, I would respectfully point out that the Bail Act itself is, apart from those exceptions, is giving the magistrates the power to grant bail in relation to all other very serious offences. And therefore it is not a stretch to say that Parliament would, if they had appreciated that it is not reasonably justifiable, etc., would also have permitted magistrates to grant bail in relation to these serious offences. More particularly since the Act establishes that system whereby you go from magistrate to High Court to Court of Appeal. Certainly it wouldn't be that the legislature would intend, from the point of view of the state and the protection of the public interest, that the state would only have one bite at the cherry, and that is before the High Court. And if the High Court grants bail, that you have no right of appeal to the Court of Appeal.
Well,
so in assessing...
Yes, I better let you develop your submissions because your time is almost up.
And my Lord, I'm very grateful for the time that you have given me as an interested party. But of course, as you would appreciate, this is an important issue for the entire legal profession.
It's a very important issue.
Thank you very much, my Lord.
Thank you very much, Mr. Mendes. Mr. Knox.
My Lords, can I deal with the existing law point first?
Yes.
First, our case is not based on the, quote, bailable, non-bailable distinction, which was found in the 1925 Criminal Procedure Ordinance. Our case is not based on that at all. It is based solely on the wording of Section 27C of the Indictable Offences Act. Or I actually think 29 as it landed up.
And D into C.
C and D. Oh, and D, forgive me. We like D. But it's, and we say, if I can just ask you to look at them in the version which was in force in 1961, as a result of the amendments then, before the further alteration to backdate everything to August 62, in the agreed note. The first point I just want to draw your attention to in reply is this. What this provision is talking to, quite generally, in relation to the court's power, in the first part of it is this. It is saying that the discretion of the magistrate under B, or of the court or a judge under 32, shall be exercised in accordance with the principles for the time being in force. It's the principles. So the question is not so much was there a jurisdiction, but the statute is saying exercise the power to grant bail in a, for murder in the case of a court.
Which document are you referring to?
It's the agreed, forgive me, my lord.
Yes, and what page?
It's the agreed note, and it's on page 2, under the heading 1961.
Right. Okay.
Yes, yep. Thank you.
But the first point I just wanted to emphasise is it is saying from now the discretion of the High Court of Justice is to be dealt with in accordance with the principles for the time being. It's not just some sort of, it's limiting it, if I can put it that way, to the principles of the High Court when dealing with applications for bail. That's the starting point, and that is the basis on which pre-committal, we say, the discretion had to be exercised by the High Court pre-committal. Then you go to the post-committal position, which is not dealt with expressly, but we say is implicitly dealt with in the second part, beginning provided that. Because we say when you look at that, the whole premise is that although it is lawful to grant bail in cases of murder for the High Court, it cannot, in most cases, it cannot do so in cases of murder. That's, say, treason penalty and so forth in subsection A, 1A. That's the premise of the proviso. That's the construction for which we contend, and we say that again is the premise of 27(1)D. And so we accept there's no express derogation of the High Court's power to grant bail post-committal, but we say this section is proceeding on that premise. And that is what we say the significance of the common law principles in relation to bail and murder post-committal is. That's why we say it matters. Because you might say, why should it be proceeding on that premise? To which we say, that's because that's what everyone assumed was the case in any event, as a matter of the common law, post-committal, in cases of murder. You just didn't grant bail post-committal. And my lords, that is why we said common law is relevant. It provides the background to the wording of section 27(1)D, C and D. It explains why it's not done expressly, because the principles in which common law was exercised for murder meant that you didn't get bail post-conviction. And, my lord, that is the significance, my lord, of the case I took you to yesterday. I'm not going to take you to it again. But it's the case of Chapman, which was decided, I think, Chief Baron Abinger's case in 1852, where he says, I've never heard of a case of bail being granted for murder post-committal, or once someone's been committed. And I can't possibly do that. And the reference is at 2241. I won't take you back to that. But that also explains Lord Campbell's approach in the duelling cases, again in 1852, which are at 1983 and 1987, Baronet Bartholomew. We said that is what the premise is, you don't do it. Now, I accept that, of course, there are very exceptional cases, like Barney's case, where after someone's been committed, the High Court says, and you come along with evidence to show that the evidence against you has been falsified or malicious and so on, then I accept that in those cases the High Court appears to have had a power to, what you might call, review the position. Say, I see you've been committed, you want bail now because I see that you've been committed on falsified evidence, or there's a good case for that. Now, my lords, I accept that appears to have been the case of common law, but that is not a reason for departing from what I say is the natural construction of section 27(1)C and D. It's as simple as that.
But how do you reconcile it with what was section 31 and became section 32? The court or judge may at any time.
Well, my lord, we say because it's saying the discretion of the judge under section 32 shall be exercised in accordance with these principles. That's accepting the principle of, that's accepting section 32 applies.
So there's a jurisdiction, but this is covering ground we've covered already. But you're saying that the practice was so entrenched that it almost became or has become a rule of common law.
But the effect of the proviso in C and D is that there is no power post-committal, and that's what we are saying. That's what we say the proper construction is. In other words,
and we have to read that limitation into section 32.
Yeah, yes, exactly. Yes. Well, my lord, my lord, that's the case. Whether you like it or not, my lord, that is our case. But my lord, more seriously, that was what the Court of Appeal found in 1992 in Sinanan.
That's true.
My lords, I don't think I need to take you any further on the existing law point. As far as the section 13 point is concerned, I respectfully submit the following simple principles apply, and then I just want to make one or two points on the facts, just all in a row, if I may. The respondent must show that the abridgment or abrogation or infringement of the relevant right was not reasonably justifiable. Not enough to show just as an abridgment, you've got to show non-reasonable justifiability. And the whole premise of Section 13 is that there is a distinction between the two.
If the test is a proportionality test, and the applicant for constitutional relief says it's not reasonably justifiable, and the very first issue is, what is the legitimate aim?
Yes.
Is the onus then on you to say what the legitimate aim is?
My Lords, I would submit, of course, I wouldn't say legal onus, but I might say it's a matter of common sense.
It's a matter of common sense.
I can't come up with any explanation of why I've taken away something.
Right. Okay, no.
It might be rather difficult for me to say I've got any reason for doing it at all.
Well, do we get the... Right. So what is the legitimate aim in this case?
Well, the legitimate aim, as it was apparent from the bill itself, which I think I showed you, was for the public safety. It's essentially to protect the public safety. And in particular, the problem of crimes being committed by people while they're on bail. Okay. And that undoubtedly, my submission, you can infer that in any event from the terms of the Act.
How is it rationally connected then? If public safety is the legitimate aim, how is that rationally connected when, in circumstances as here, bail was never granted in murder cases?
Well, my Lords, we say this. Can I answer that in a moment? Because I was just going to run through my propositions, and then they will come in. I will answer that specific point if I may. We say for the purpose of the test, you look at all the circumstances prevailing in 1994 as a matter of fact. And you do that without reference to what I say are rather high-flown concepts such as core judicial functions, fundamental values, and all that. In my submission, those are misleading concepts. Just look at the simple matter of fact, as things stood in 1994. And in particular, you look at those points or those matters that were put before Parliament for its consideration. You don't consider matters which might now have been put before Parliament in the light of developments since then. You look at things as they stood in 1994. And one relevant question is the question of proportionality. I entirely accept that. But the mere fact of disproportionality is not conclusive. And so, and this is, my Lord, this is the point I want to make in particular, the mere fact that in the board's view there is a lack of rational connection between the law and the aim it was seeking to achieve is not conclusive. In my submission, that is a wrong approach in principle, because the question for the board is not whether the law was, quote, justified, but whether it was justifiable, capable of justification. And on the question, therefore, rational connection, the question is whether Parliament could reasonably have taken the view that the law was justified, given the circumstances of the time. That's the question.
Could reasonably have perceived that there was a rational connection.
Yes.
And you say mistakenly they didn't.
Well, they perceived, well, I'm going to come to that if I may. So we say they could take the view they did. First of all, because the non-grantability of bail for murder reflected not only the government's view of the existing law, but it also reflected, obviously, their view as to what the law should be, and also that expressed by the Constitutional Commission in 1990. My Lords, I took you to paragraph 110 of the Constitutional Commission report, where they said in terms, we do not think the denial of bail should be extended beyond the scope of murder and treason and so forth, but for that, it should stay as is. So, and I submit that is an important point. Parliament has that before it. And it was, the Constitutional Commission's report was referred to in Hansard. So on the material before Parliament, they've got the Constitutional Commission saying, well, there's no reason to extend bail to cases of murder. The Constitutional Commission's point was you should not take that prohibition against bail to other cases as well. But I submit that is something that one takes into account in deciding whether Parliament what they did was reasonably justifiable or not, or whether there was a rational connection. Now, my Lord, can I say an answer to your question, my Lord, is this. Although bail had not been granted in the past for murder, so to speak, that's the point against me, it was, in my submission, not unreasonable for Parliament to assume that if you did permit bail to be granted for murder, as it had been in the past for other offences, then the same problems would arise as had happened in relation to the grant of bail in the past for those charged with less serious offences. In my submission, that's not an entirely unreasonable view to take. You might say it doesn't necessarily follow, but other people might say, well, murder is, after all, traditionally regarded as the most serious crime in the book. Why should you assume that people who are let out on bail for murder will be any more reliable than those who have been let out on bail for less serious offences? Now, my simple point is that's not an unreasonable point of view. You might say, oh, I don't agree with that, but that's the point I'm on. I just say that's for Parliament to decide. So if you're satisfied that Parliament simply couldn't have had any rational reason for doing what it did, I accept. I'm out. But I say there was a rational explanation and an understandable explanation for why Parliament took the view it did, and why it just didn't occur to anyone to say, let's grant bail for murder, as a general proposition. But as far as the post-committal point goes, my lords, it goes further, because there was plainly a good reason post-committal for supposing that that under the law as it stood, bail couldn't be granted post-committal, because Sinan had recently decided that in 1992. And Sinan was binding. So it was perfectly rational for Parliament in 1994 to say, at least post-committal, well, there's no problem in prohibiting bail to that extent. And my lords, I submit it would be a very strong thing to say that Parliament, there was no reasonable justification for Parliament to take the view post-committal that bail can't be granted. There's no reason for Parliament to take the view that the bail should be, effectively the law should be changed from that which had recently occurred to be. How can that be said to be not reasonably justifiable? That's how we put it post-committal. Of course, nowadays we say, well, you might say, we think Sinan was wrong. No one said that in 1994. And my lords, I know in one sense I sound as if I'm the advocate for Parliament, so saying, we're not as bad as all that, you know. And I am, in one sense, being an advocate for Parliament. But I submit that one should be very careful before saying Parliament, with the material before it, in all the circumstances, has made a law at the time that was not reasonably justifiable in a society with proper respect for the rights and freedoms. And I do in particular, that's how I answer your Lordship's point.
One of the paradoxes in this case is that you are in fact advocating for some discretion to be given to judges, but by a constitutional route, as opposed to. So so public safety can be met by the constitutional route, but can't be met by bail.
Well, I would put it the other way around. I say you can have a general law exactly as passed if, in very unusual circumstances of the sort which hardly ever arise, and it's not suggested have ever arisen, in fact, and certainly not in this case, if you have a very unusual situation where, let us say, the prolonged detention of a prisoner on bail, pending a charge of murder, there may well be constitutional remedies available to you to say that it's cruel and unusual, or there's an abuse of the process, or whatever.
But it won't be bail.
So it wouldn't be bail as such, but you would be able, but the Constitutional Court would have a power to fashion the remedy for whatever, depending on what the circumstances were. Supposing you put a case to the DPP, he said, I'm not interested, you could then review his decision. It's not hopeless. It's not as if once you've refused bail, there is nothing that can be done. If the prosecution is an abuse of the process, well, you simply stop it as an abuse of the process. So, my lords, a lot of the argument against me, I respectfully submit, turns on the notion there's nothing that can be done once you've been denied bail and you're awaiting trial. In my submission, that's not the case. So, my lords, obviously, what I'm doing in real life is I'm ameliorating what you might call the effect of the Bail Act by saying, well, it is expressed in clear terms, but it doesn't follow from that that all avenues are closed off in the case where special circumstances arise.
You're not arguing that there's any remedy for the accused person who is on remand for 15 or 20 years?
My lords, I'm certainly not saying there isn't a remedy for him.
You've confined your concession to a case where there is evidence which demonstrates the innocence of the accused person. So in a sense, you are saying that gross delay will not give rise to a constitutional remedy.
Well, my lords, there is a case called Tokai, which actually isn't before you. It was in 1996. It was a case from Trinidad. And the point was taken, I think, by Mr. Tokai, that this trial, I've been waiting around in prison for quite a long time, and I want my trial to be dealt with as soon as possible. And he said, and his application was turned down on the footing there is no provision in the Constitution which provides for a trial within, quote, a reasonable time. And so the Privy Council said, well, you have no constitutional right as such to a trial in a reasonable time. He wasn't complaining about absence of bail, but he was complaining about absence of trial within a reasonable time. So I accept that there is no constitutional right as such to turn up after 5 years and say, I want bail because I've been waiting around too long. That is right. But on the other hand, my lord, if it certainly doesn't follow that you can't apply to the court in any event and say, my trial should take place sooner. It's an abuse of the process that I'm being made to wait so long.
Do you have a reference for the 1996 case?
My lords, I don't, because it's not in the bundle, but I was looking at it while Mr. Ram Logan was on his feet, but we can send it over to you. It's 1996, 2 appeal cases, and it's T-O-K-A-I, yes.
Thank you.
Is it there? Is Tokai in the thing? Oh, it's referred to in other cases, but it's
referred to in your case.
No, it's not referred to in our case. I said in
other cases.
In different cases. We will send over a copy to you.
I do recall it. Yes.
So, my lords, that's how we say. That's what we say about the rational connection test. It's not for you to say whether there was a rational connection. It's for you to say whether or not Parliament could reasonably have thought there was a rational connection. That's what I say the test is. And there is a difference. That's the first point I want to make on Section 13. The second point is a point your Lordships already have. I just want to emphasise, though, the effect of what has subsequently happened after the Bail Act in 1994 is irrelevant. You cannot judge the reasonable justifiability of the Act in 1994 by reference to whatever circumstances might have arisen after that. So it doesn't help, in my respectful submission, to refer to the prison conditions or the delay that trials have subsequently taken. That is not an issue. The question is simply, at the time, was it a reasonably justifiable law? If it was, that's an end of it. Whatever's happened afterwards as a result of it. I might add this, my lords. In real life, given that bail was never granted before the 1994 Act, it's very difficult to see that the passing of the 1994 Act has actually made any difference in practice to the problems which Mr. Ram Logan referred to. My lord, that deals with Section 13 in answer to Mr. Ram Logan's submissions. In answer to the Law Society's submissions, my learned friend Mr. Mendes has said you should take a narrow construction to Section 13. Well, I accept this much. The general rule is when one is talking about derogations from rights built into the Constitution itself, such as the existing laws clause, that is correct. There is no basis, however, for saying that in relation to Section 13. First of all, just as a matter of language, the word justifiable, reasonably justifiable, does not, in my submission, is not ambiguous. And it plainly is not the same as justified. Secondly, that would lead to a problem, because sometimes what really happens, and happened in Surat, is Parliament passes a law which might derogate or at least infringe or abrogate to a certain extent one right, but in order to increase another right. So, for instance, you pass equal opportunities legislation, which requires employers to have an equal opportunities policy. Well, in one sense, that is actually depriving them of their right to choose who they like. You might say it's all in a good cause, but undoubtedly you might be infringing their right to enjoy freedom of property, and so on and so forth. One can think of lots of examples. So to say that you adopt a narrow construction in relation to Section 13 would lead to, in my submission, all sorts of anomalies when you have statutes which plainly are designed to readjust the balance of rights, existing rights. My Lord, just a point on the use of Hansard. My Lord, in Francis, the Court of Appeal decision, it was accepted that one can have resort to Hansard when one is trying to work out, as it were, the general aim of the legislature. And if I can just give you the reference, it's 1556, paragraphs 260 to 261. And the stringent, the restrictions which normally apply to interpretation of legislation don't apply. My Lords, I have a feeling, Mr. Goldblatt, I think, will confirm this to me, that in Bank Mellet, they actually looked at Hansard. I may be wrong about that. Is that right? Sorry. Lord Reid in the minority referred to Hansard in Bank Mellet, but I don't think he was in the minority on that point. But in my submission, it is legitimate, when you're considering the objective and the concerns of Parliament, to have resort to Hansard. And my Lords, in particular, I do submit that one can do, as I did yesterday, you can look at the Attorney General's speech introducing the legislation to see what the objective was that it was seeking to achieve. And my Lords, finally, on the question of severance, my Lords, Lord Stevens and Lord Hodge have put various points to Mr. Mendes, which I respectfully adopt. You would effectively be legislating if there is an inconsistency between Section 13 and, if, to the extent Section 13 is inconsistent, it is void only to the extent of the inconsistency. It's as simple as that, quite regardless of any existing law point. And, my Lords, I respectfully submit there is nothing inconsistent with the scheme of the Constitution, if it were the case that the power to grant bail is limited to High Court judges. It's a matter for Parliament if they want to change that. And that's the short point. And, my Lords, I do also urge, in relation to the Section 6.2 point, I do respectfully submit, if I am right in saying that Section that there was always a prohibition on bail being granted post-committal, then one can use Section 6.2 to rescue what you might call the post-committal position. And likewise with Section 13. If I'm right in saying that Section 13 simply is unconstitutional simply insofar as it restricts the grant of bail after, so pre-committal, well, I said that is the board should so declare. And, my Lords, I would just like to say one thing. Why is it not reasonably justifiable to limit the grant of bail in cases of murder to pre-committal? Once you've been committed, the evidence has been found to be there, and there's a strong, there's obviously a sufficient case to go to trial. It's not immediately obvious why a law that goes that far could possibly be said to be not reasonably justifiable. Whatever the position may be pre-committal, post-committal, I submit it's a very different position. My Lords, those are my submissions.
What about the breaches of Articles 4 and 5?
Well, my Lords, I would like to kind of give you an indication, because I think it's important that, for the purpose of my client, these are very important considerations. But I think I have accepted there is a breach on the face of the 5.2. I think it's 5.2F3, which is the effect of this law is to deprive an accused person of the right to go to the High Court and obtain bail in circumstances he could previously have done. And I accept that in certain circumstances. It's a very limited derogation, but it is a derogation for certain types of people, but not for all people. It may also be, I can see that as far as Section 4 goes, it might be said there's an absence of right to the due process of the law because you can't go to court. You are no longer able to go to court in that type of special case to ask a judge to give you bail pending your trial. I can see the due process because you're being you're
And
no longer
4B
go to court.
as well.
Sorry?
And 4B, protection of the law, which
Well, my lord, whether
you agreed to that yesterday, but perhaps you're not agreeing today.
well, I'm not sure I agreed it yesterday. I took you to it yesterday, but I
Lord Stevens has asked you to confer with the Attorney General and give the board a note of your position. I don't think it's fair on you or the Attorney General to make you do it on your feet, but beyond giving a general indication.
Yes.
You will rely on the document that you produce.
Yes. Yeah. But my lords, that would be our position. But you have my submissions, unless there's anything else, my lord, that we'll have to say.
No, thank you very much.
Can I give you a reference to Tokai?
Yes.
It's 1996 appeal cases, page 856.
856.
And can I, pro tem, hand up, principally to my Lord Stevens, a copy of the
frontispiece.
frontispiece? Yeah. And I'll email it to you as soon as I get access to email.
Thank you. Thank you very much indeed. Very kind.
Very much.
I think you give it to Lord Hodge. It says Lord Hodge is the presiding judge.
The board is very aware that this is an important matter for the criminal law of Trinidad and Tobago, and the board is very grateful to counsel for their submissions, and also to those who have assisted counsel in the preparation of the cases that have been presented to us. The board will take time to consider their judgment. Thank you.
My lord, I'm sorry, just as you rise, it occurred to me there was a note which we received yesterday with all the different jurisdictions and the different laws they have in relation to bail. We would like an opportunity to put a reply into that note, because we only saw it yesterday.
Yes, of course. 7 days? 7 days?
Quite a detailed note. I can't.
Well, as soon as possible. Thank you.